Yes, Mr. Lewis.
Well, thank you. May it please you. Before the short adjournment, I was addressing the board on the question of the discretion, and I hope to be able to wrap this up very quickly now. One might rhetorically ask, how does lateness fit into the merits decision that Justice Wallbank took? And the answer is, it doesn't feature at all in the merits decision. And that's because, as we have already submitted, Sian's broad argument, lateness being just one factor, makes the fundamental error of conflating the procedural or evidential discretion with the merits discretion. There is nothing in the first instance decision to say that the judge took account of lateness as a factor in the exercise of the merits of the winding up. Now, there are several specific points my learned friend takes against me in relation to discretion. Those are answered in my written case, starting at paragraph 124. I won't trouble the board with the majority of those now, but I would remind the board just of one or two points that we made, and a fairly fundamental one is that their third and fourth points, we deal with this at paragraph 128 of our case, are not arguments that were taken below and are therefore not strictly available on this appeal. The procedural chronology is given in detail in our written case, paragraphs 134 to 136. Again, I won't review that step by step now. I've made the fundamental points on it already. I think there are only two additional things that I should mention or show. The first is that I mentioned that the learned judge had made a case management order for no more evidence. It's dealt with in the SOFI at paragraph 17, 785. The hearing on Monday, the 30th of November, Wallbank J adjourned the application and, quote, gave directions for further evidence to be filed by Sian by the 18th and by Halimeda by another date, quote, with no further evidence to be filed by either party without permission. So that was an order that the judge made to manage the process, knowing the nature of what was going on. The order itself, should the court want it in due course, is at page 76 in the bundle. The second point to make... 76, thank you. Thank you, my lord. The second point to make is that Sian gave no explanations at any stage for its delays. And the judge resolved on his case management function against that. He was just presented with this cloud of objections coming and going, and orders being breached and deadlines missed, and a strikeout being launched to get around that very order that I've mentioned. Faced with all of that, he then exercised his case management powers. The rest is dealt with on these points in our written submissions. I mentioned this morning a case in this tribunal, or before this board, which held that the court has a discretionary power to make a winding up order even where the debt is genuinely disputed. And I should just give you, it's Parmalat Capital Finance, and the relevant passage is at paragraph 9, and the references are tab 55, 2147 at 2150. So if the discretion can override a genuine dispute leading to winding up, there must equally be a discretion to wind up even when there is an arbitration agreement more broadly. Yes, learned friend's written argument includes a point, paragraph 94, that a court cannot properly exercise its discretion in these circumstances if it excludes consideration of the arbitration agreement. Now, the answer to that we give, the fundamental answer, is at paragraph 149 of our written case. And it is this, that the corollary of what they say is that a court would then be precluded in every case from shutting out arguments or evidence said to be relevant, regardless of when or how raised or reduced, and regardless of the procedural conduct of the party seeking to raise them. I hardly need to develop that submission. Unless the board has questions, which I readily invite, on those points, I now move to my second head, which is whatever the test, it was satisfied on the facts of this case. And in this section, I will look, if I may, at the test in Salford and Jingpeng and try to explain how they come to be. So, learned friends put in at the front and centre of their case the relevant standard. Salford, exceptional circumstances. We say, Jingpeng, whether the debt is disputed on genuine and substantial grounds. As a preliminary point, we observe that the disputed on genuine and substantial grounds test, if correct, was correctly applied by the judge and the Court of Appeal, and there is no appeal against that. If we've got the right test, there is no appeal that it was applied there is no ground of appeal that the test was applied wrongly. The second point is that if Jingpeng is wrong, contrary to my overall submission, how does the Salford test work and why? Now, if I can start at this point. In England, where a creditor is owed a debt by a company, the company need not have an answer to the debt to avoid being wound up. It's sufficient for the debtor to say, but I have the benefit of an arbitration clause. And therefore, unless there are exceptional circumstances, you can't wind me up until an arbitrator has determined the underlying dispute. And it doesn't matter whether or not the debt is undisputed or not admitted, whether any answer is given. Merits are wholly irrelevant if you press the arbitration button other than in exceptional circumstances. That's how stark the Salford test is and why it's wrong. In the BVI, by contrast, the debtor does need to have an answer to the debt itself. Because unless the debt is disputed on genuine and substantial grounds, the debtor will be wound up, and that's Jingpeng, and that's regardless of the presence of an arbitration clause, because the question is, does the debtor have a substantial answer? If the debtor does have a substantial answer, then the matter may very well be referred to arbitration, if that's what the clause says. But the first question is there a substantial dispute? Now, what is the critical difference between the law in England, analytically, and the law in the BVI? The difference is not, as one might imagine, the genuine and substantial grounds or bona fide dispute test. Those are common to both jurisdictions. The difference is the addition in England of the exceptional reasons test in the presence of an arbitration clause. The difference in England is the addition of the exceptional reasons test in the presence of an arbitration clause. Now, this perhaps is the core issue on the Salford dispute, because in our submission, Salford completely reverses the ordinary discretion on a winding up petition by imposing a stay in every case where there is an arbitration clause, unless exceptional circumstances can be shown. And that, to use the language of a judge in Hong Kong, whose decision we'll look at in a moment, to use his language, it totally fetters the broad discretion. Lord Burrows, if I may respectfully say so, put his finger on it this morning when he said words to the effect of what Sian is really arguing is that there should have been a mandatory stay, because what you're achieving is the mandatory stay by fettering the discretion. Why is it that? Well, the fettering of the discretion makes the discretion a non-discretion, because the exceptions will hardly ever arise. And the learned judge, the learned chancellor, recognised that himself at paragraph 39, where he said, immediately after the words, save in wholly exceptional circumstances, he said, which I presently find it difficult to envisage. He recognised that he was imposing effectively a mandatory stay, even though he said he wasn't going to. Now, in Hong Kong, at first instance, the deputy judge, in an extraordinarily learned judgment in our respectful submission, Mr. Wong, senior counsel, in a case called Diane, which I'll show you, said that fettering, this is paragraph 96 at page 1311. Could we get that up, please? 1311. This is a case that was referred to before, but learned judge who reviewed everything at length, and Lord Burrows asked whether there was any learning on this. May I just say that we will present a list of all the articles that we found without commentary. We don't find many of them very helpful, but we would say that this is the best learning. The above authorities clearly establish, this is 96, the court has a flexible discretion and so forth, where the debtor company could show a bona fide dispute on substantial grounds. So if one, you show the bona fide dispute, two, you have a discretion. We've seen from Parmalat that can be used either way. However, by requiring the courts to dismiss or stay a winding up petition, as long as the threefold conditions, that is a defined term in the judgment, and I can show it to your lordship, but what it means is the threefold conditions include the requirement for exceptional circumstances in these sorts of circumstances, have been satisfied. The Salford-Lasmos approach, Lasmos was a case that a learned friend referred to before, and it's one where a court went in our submission slightly wrong in Hong Kong by requiring arbitration to be started. The Salford-Lasmos approach is antithetical to the nature of a discretion and represents an unprecedented fetter on the court's discretion. You can't get much stronger than that. That decision was reviewed and upheld in a different case, which has also been mentioned today, in the Hong Kong Court of Final Appeal, in a case called Guy Lam. So if we could go to the supplemental authorities bundle, please, and turn to tab 6, page, I hope I'm going to get this right. No, that's wrong. I'm sorry, 1 minute. Forgive me. I'll come back with the reference. No, I've got it here. 1 second.
Court of Appeal.
No, I know. Thank you. Yes. Yes. Sorry. 92.
It starts at 92.
I don't want the court of appeal. I want the final appeal. I'll come back to the reference. The Hong Kong Final Court of Appeal.
It starts at 92.
Yes, that's the Court of Appeal. I'm afraid it's not the final appeal. It's
1644 in the main bundle.
1644 in the main bundle. Sorry, I have got it marked. I'll find it. Yes. And it's yes, I've got it now. My apologies. It's paragraph 93, I believe.
Page?
No, I've got that on the screen. Yes, I've got the wrong paragraph. Thank you.
1678.
Yes, I may have meant to refer to the other one. Sorry. Yes, forgive me. Now, I will retrench, go back to the supplemental authorities bundle. Forgive me. It's because we kept changing the authorities around. So my mistake. Supplemental authorities, page 129, and we're in the Court of Appeal, not the final Court of Appeal. Paragraph 93. On the question whether public policy against fettering a statutory right is called into play, I find with respect the analysis of the Deputy Judge, Wong Senior Counsel, compelling. And then he sets out what he meant two lines further on. He considered there is no reason why a creditor's voluntary surrender of rights to petition for winding up should be held to be unenforceable for being contrary to public policy and so forth. Now, the decision in Guy Lam shows that yes. So I was dealing with the sulfur test. The third criticism of what it does is it puts the onus on the creditor to show exceptional circumstances, whereas the serious dispute on the debt test, once the creditor has put forward evidence of the debt, then the onus is on the debtor to show why he shouldn't be wound up. Now, in analytical terms, and coming back to the core argument, why does this matter? In our submission, it's this, that a bona fide dispute is a sufficient answer in both England and the BVI if the debtor gives an answer and meets the test, then the arbitration clause is irrelevant in both. I have a bona fide dispute. I don't ever have to point to my arbitration clause if I don't want to. The difference is that in England, whilst in England the demonstration of a genuine and substantial grounds is a sufficient answer, it's not a necessary answer because another answer could be given. In England, as I've already said, the company need give no answer on the merits. It can just point to its arbitration clause. Now, that's wrong, and that's what this appeal is about. The company can completely avoid putting anything forward on the merits in England.
Can I just ask, I was just left a little confused
Yes.
about what you're saying about the Guy Lam case.
Yes.
you were taking us to the Court of Appeal.
Yes, I was.
And then, but did something then happen in the in the final Court of Appeal?
The answer is my notes are in a mess, and I'm going to sort it out and then tell you, rather than tell you something that's wrong, if I may.
Right. Okay. So we put that to one side for the moment.
Put that to one side. It's really not the heart of what this is about, because the fundamental point is the analytical approach between these two jurisdictions. What's the reason for preferring the rule in Jinpeng over the approach in Salford? We offer at least three not mutually exclusive reasons. First, Salford creates an additional rule that effectively converts a discretionary stay to a mandatory stay, Lord Borough's point. I've explained that already. Second, the rule in Jinpeng avoids abusive invocation of the arbitration agreement, such as in this case. The BVI considers a purported desire to go to arbitration with a lack of any genuine and substantial explanation as to what the arbitrators are going to decide as no more than a ruse. They say, yes, you can go to arbitration, but it's not a trump. You must show us what the arbitrators are going to be deciding. And this case is a perfect example. The third reason is that there is a consistency with the no proper purpose jurisdiction, which is just beginning to develop in this court, this board, and in the Supreme Court in the Mozambique and family mart cases. The principle is the residual discretion not to stay proceedings where the applicant has no proper purpose in seeking a stay. So you say, you're invoking your arbitration clause, but I'm not going to stay, in those cases, not insolvency, but stay a court hearing or a trial or whatever it might be, because you've got no proper purpose in going to arbitration. Now, it's a developing jurisdiction. The court has looked at it in two different contexts recently. I don't want to put too much store by it, but there is consistency in our approach by saying that the arbitration agreement is not final. In these sorts of circumstances, the paradigm example is in liquidation, or on a winding up petition, where you can't show that you want to take something to arbitration. And we say, if the court has a jurisdiction to refuse to grant a mandatory stay under Section 9 of the English Arbitration Act, then the court can and probably should refuse to grant a discretionary stay in these sorts of circumstances where the debtor has no proper purpose in asking to go to arbitration, because the acts don't apply to liquidation. If I'm wrong about all of that, and Jinpeng is wrong, and the Salford test is too high, what should the test look like? Now, we say exceptional circumstances sets the bar too high, and that a lower standard should be applied. This is, as Lord Hamblin observed earlier, not an area we don't accept that there is any clash of policies, because there is no policy, because the statute doesn't apply. But if the court is looking for a test to apply over and above the genuine dispute test, then where should it be set? Now, we say that a mandatory stay is too high, a discretionary stay, the mandatory stay is not available. The only stay would be discretionary and therefore should be resolved to a lower standard. There are three key reasons for that. If it were left at the Salford level, we first of all got the point that I've already made, that the discretion set at the level of Salford removes all the discretion altogether. There is no discretion. The exceptionality. Secondly, Salford prevents the court hearing a winding up petition from striking a balance between the different interests, such as there might be. And thirdly, to put the first point in a different way, it applies the mandatory stay by the back door. So what should it be? We are not wedded to any of this, but we would suggest that if the court is looking to impose an extra hurdle, and we strongly urge the court not to, but if it's going to, then it should adopt a principled approach, looking for a standard that's lower than Salford, but higher than Jingpeng, because the board will have on this set of assumptions decided Jingpeng is wrong, but the standard should pragmatically distinguish between unmeritorious cases from those in which a winding up petition should be stayed in favour of arbitration. And we would posit that the most fitting is the test to be borrowed from the exclusive jurisdiction clause test in Donohoe and Armco and so forth, and that's the strong reasons test. Strong reason not to refer to arbitration. Less than Salford, more than Jingpeng. That was adopted in Guy Lam, which was an exclusive jurisdiction clause case on a petition. It remains the law and has been since Lord Bingham gave his classic judgment in Donohoe and Armco, Authorities 271357, and it historically applied where a stay of a claim was sought in favour of arbitration. Now, leaving that aside...
But not in the winding up context.
Not in the winding up context. So, as I say no extra hurdle, but if the board is looking to make some law, as it were, or to declare a uniformity or a harmonisation of law, I offer that as a proposal, no higher. But I say that whatever the test, and I set my aim now at the highest test, even if exceptional circumstances were the test, and the judge in BVI misdirected himself, then we say we meet the highest test in this case, for the reasons I will explain in a moment, whether that be exceptional circumstances, abuse of process, Anne, learned friend's favourite case, with respect to him cut and pasted throughout his written submissions, or thirdly, strong reasons by analogy with Donohoe and Guy Lam. The three factors we say, we identify, which put us into the position of saying that in this case we met the most stringent of those tests are these. I'm going to take the third that we identified in our written case, that's 110 sub 3, first, because it in itself would suffice. The other two we can add, but the third one is enough. The third factor is the issue of the civil claim for fraud damages in the BVI commercial decision in respect of the self-same so-called corporate raid that is discussed in my learned friend's skeleton. Now, we get that from the Sophie at paragraph 11, page 784. Now, that was done whilst the petition was running, and in fact, it was done, we say, to persuade the liquidation court that there was something serious to be argued about, because they exhibited, Sian, the claim form and statement of claim to their strikeout application, and that's dealt with in the Sophie at paragraph 17, so it's a matter of record as well. 785. BVI civil proceedings are raise exactly the same complaints that are said to have been eligible for reference to arbitration, and there is no other matter that would have been, because the debt is now not disputed, as we've seen. Now, the key point here in our submission, and we deal with this in our written case at 114, is that Sian's invocation of and submission to the local court's jurisdiction in the BVI civil proceedings, whilst also insisting on a stay or dismissal of the petition in favour of arbitration, amounts to the most exceptional circumstances. If the Chancellor needed exceptional circumstances, these are the ones.
But is this really for us? I mean, if he's applied the wrong test,
yes,
does it have to be remitted?
The answer on that is that, first of all, learned friend raises the question of whether or not there was repudiation, and that's a red herring. This is not a question for the arbitrators as to whether or not there could be an objection to arbitration. Secondly, the question, therefore, is whether or not there were strong grounds or exceptional grounds for refusing to send this case to arbitration. And that is a matter, in my respectful submission, that your lordships can look at. Why? Because it's a matter which does not require very much thinking about. It's a very short point. The only question would be, by invoking the jurisdiction of the local court at the relevant time, has the debtor demonstrated that they are engaging, that they are not engaging the right to arbitration.
But you're not saying the arbitration agreement is repudiated?
No, I'm not. I don't need to go that far. My distinction, we made this point, I think, in our written case. I think it's 112 to 14. We talked about Russell and arbitration, and we look at cases like Marty and Huelon, but we make those points in a different regard, because we say that the question for the court is whether the commencement of the civil proceedings met a threshold, however high, for not referring a matter to arbitration, not for the resolution of whether or not the arbitration agreement had been repudiated. It's a different question. It's a threshold question. So, and what we say is that it is as plain as it could be. There is no more clear circumstance that at whatever level we set the threshold, a court deciding whether or not to stay or not to stay, not because the arbitration agreement has been repudiated, but because there has been contradictory behaviour demonstrating that the case will not be brought in arbitration, but will be brought in litigation.
So you say that's a powerful discretionary reason?
Yes.
But it's not our discretion, is it?
Well, Lord, I see the issue, but is this court going to, as it were, declare what the discretion is, what the threshold is, and then remit this to a judge to decide that one short point? Now, I do see that there is a problem with exercising a discretion separately, But given the brevity of the point and the waste that would be caused in remitting that one short point for an inevitable result, then, in my submission, this court should deal with it. Of course, if you set the threshold lower, it becomes even more interesting. There are two further exceptionality factors. I'll deal with them in a second. Firstly, there's no dispute, or at least no longer any dispute, that the debt is not disputed on genuine and substantial grounds. I've shown you the Sophie on that. There's also no dispute that this party did not refer the matter to arbitration, and that is a matter the judge did consider. So he knew that there was litigation, and he knew that there had been no referral to arbitration, and he referred to both in his judgment. So it may be that the answer to Lord Hamlin's question is that the board would be able to see enough from what the judge said in that relevant part of his judgment. I think it's in the Sophie at paragraph 24, to say he had these matters in contemplation, he resolved the case exercising that discretions in relation to those matters, and whatever test he was going to apply, that those matters were already in his contemplation. I don't think I can do better than that. Unless there are more questions on this area, may I move swiftly, as it were, to the next point, which is even if Salford is correct as a matter of English law, it is not the law of the BVI, and there's no reason why it should be. Starting point here is that whatever may be the appropriate balance between insolvency and arbitration in England, in the BVI Eastern Caribbean, and I should say that a precedent set in the Eastern Caribbean Court of Appeal generally binds all the Caribbean islands, as your lordships know. So it's broader than just the Eastern Caribbean. So Jinpeng will be held to be the law across the Eastern Caribbean. In the BVI Eastern Caribbean, it must, we say, be struck in favour of the protection of the public from the continued trading of insolvent companies. And we say that the BVI Eastern Caribbean courts have specifically chosen not to follow Salford, and that this board should not impose an English choice, an English policy choice, because although it is correct to say, as Lord Hamblin said earlier today, that absent a statutory framework, no relevant statutory policy, but the Chancellor did apply and expressly applied what he called the policies of the Act. And he referred to the policy of the Arbitration Act in the critical paragraph of his judgment, 39, I think. So BVI and Eastern Caribbean courts have elected not to follow Salford, and that was with their eyes wide open, because they read and considered Salford in their decision-making. Now, why do we say that there are strong reasons for taking a different approach? Well, the territory in the BVI, the geography of the liquidation framework, is different from England. The BVI has over 300,000 registered companies. It has a very active companies court, which hears regular applications for the winding up of companies. Most of the companies in the BVI are shell companies, established to hold interests in other companies, or to hold interests for the reasons that learned friend gave, tax, convenience, structures, whatever it might be, in other parts of the world. The owners of those companies tend not to be, from experience, based in the BVI, and the operations tend not to be in the BVI, and very importantly, there are very rarely other creditors on a winding up application. Usually there is one creditor, and that is, in this sort of transaction, the counterparties to loan transactions. So an offshore shell is inherently less likely to have local creditors than an English company, which will generally have local staff, rents, offices, suppliers. So on a winding up, learned friends say, well, other creditors can look after themselves. If you've got an arbitration clause, off you go to arbitration, but the other creditors can look after themselves. With the BVI, that's rarely the case. So it becomes a charter for abuse. Because if Salford applies in the BVI, the local courts generally, there is a greater risk of depriving the local court of any meaningful control over its potentially insolvent companies as compared to a jurisdiction such as England. Now, one very important, for example, distinction between the insolvency geography of the BVI and England is that although the BVI Insolvency Act contains a regime for the administration of companies, like in England, it's never been enacted. And why would that be? My submission is that it hasn't been because the administration of the regime tends to be company-friendly. Gives the moratoria and so forth, to the detriment often of creditors. While the company tries to work out its affairs, it can't bring proceedings, creditors can't take proceedings against it and so forth. In England, there is an administration jurisdiction, so the balance is different in the BVI. And it is different because of the nature of the operating companies. It's different because of factors such as the administration. It's different because of Section 168 of the BVI Insolvency Act, which I refer to in certain places in my written submissions. Section 168 requires a winding up petition to be resolved within 6 months or be dismissed, which gives you terrible problems under the vulnerability period. Because if you have to issue another one, you lose the benefits. And if you're going, as I say in my written submissions, if you're going to seek to extend it, it must be extended every 3 months. And you have to put forward, I forget the adjective now, but you have to put forward sufficient reason, I think it is, for extension. Learner, for instance, we can do it on paper, it's easy. But experience tells you that it's not always straightforward. The other big difference between the BVI and England is that England has become very arbitration friendly. It's promoted, and we have an active arbitration community, and many arbitrations take place here. Last week, I'm told by my instructing solicitor who attended BVI arbitration week, there was a report as to how many arbitrations had taken place in BVI under the auspices of the Arbitration Acts at all in the last, we think it's about 5 years, and the answer is 10. The arbitrations are not going to take place there. A lot of friends may say, well, it doesn't matter, it can take place anywhere. But the fact is that there's less supervisory control. So we say there are strong policy reasons for the BVI Eastern Caribbean approach, and they have chosen that approach themselves. And it's not, with respect, for this board to change their law unless there is a very good reason to do it. And in fact,
might it be said against you,
yes,
that if there aren't usually any other creditors involved,
yes,
it might be said, well, one of the arguments in favour of, if you like, preferring the winding up procedure is that it's an action based on the interests of all the creditors, as opposed to just the creditor and debtor to this particular dispute. But if there aren't going to be other creditors, might it not be said that arbitration might be said to have a stronger reason to be given prominence?
Well, it might, and I'm sure now it will, but it won't be the answer with respect, because the threshold is there something to go to arbitration? That's the real point. And giving the arbitration trump to the recalcitrant debtor just lets them play for time. That's what's going on here. There are several reasons why we say that the BVI should be allowed to be different. And with an eye on the clock, I need to pick up my pace very slightly. The first is that the local courts should have autonomy, unless there is a good reason for them not to. It's common ground, see my learned friend's case at paragraph 80, that Sian has, quote, always accepted that there's no reason why the law of the BVI must inevitably be the same as in England. In our case at 87 to 88, we rely on the decision of this board in the Australian Consolidated Press and Uren case, which my learned friend referred to before. He gave 3 reasons for there being distinctions. In fact, I think there are 5 reasons for being different. 1, again, that uniformity of approach. This is 1113, 64. I'll give the bundle references. 1113. Again, that uniformity of approach may yield is far less marked in some branches of the law than in others. And our submission on that is that this is winding up is a paradigm example of an area of the law which should be left for local jurisdictions to manage, because there is no need, as in, for example, international trade cases, for homogenizing the law across common law jurisdictions. 2, development may gain its impetus from any one and not from one only of those parts. This is also at 1113. The law may be influenced from any one direction. Now, that's important, because one can develop an Anglo-centric view of these things because of the learning in this tribunal. But the local board, the local tribunal, the local court of appeal is very learned and has decided for itself, eyes wide open, to it differently. And maybe they were right and we're wrong, in which case that will be a foundation argument for why Salford is wrong. We could learn from them. Thirdly, there is the point that I've just made is made again at 1113, in particular in matters which may considerably be of domestic or internal significance. The need for uniformity is not compelling. That's just a development of the last 2 points. Fourthly, was held at 1114 that an issue the permission to apply different rules to awards in that case of exemplary damages was held to be, quote, an issue resolved not so much by asserting that reasoning can lead to only one conclusion, but rather by coming to a decision as to what the policy of the law should be. Now, Salford is a policy-driven decision, the point that's in issue. And there is, because we point to the discretions that are engaged, and Salford plainly put itself in the land of policy, there is not only reasoning that can lead to only one conclusion, but the policy of the law should be sorted out by a decision, and that's a local decision. Lastly, the law, this is 1116, the law should not have developed by process of faulty reasoning and should not be founded on misconceptions. Learned friend addressed the board on that. Now, to pick up just a few of those points very quickly, some of them I've already addressed. Firstly, the law did not develop by a process of faulty reasoning or misconceptions in the BVI and the Eastern Caribbean. It was said that Jinpeng may have been decided without really understanding what Sea Mobile was about. But one member of the constitution of the court was in common. Friend didn't tell you that. That was Justice of Appeal Kentish Egan, who was in all three cases, C1202, 1202, 1216, and 1809. Secondly, there was no faulty reasoning or foundational misconception because the Court of Appeal in Jinpeng and again in this case had full sight of and full argument about Salford Estates and agreed with the Chancellor on many of the points. They just disagreed with the point of departure at paragraphs 39 and 40. So in agreement, it was held in Jinpeng at 45, page 1831, a winding up petition is not covered by Article 8 of the Model Law. It was agreed there was no grant of an automatic stay, same page. It was agreed that the court retains its wide discretionary powers to stay or dismiss. But at paragraphs 45 to 46, as my learned friend has told you, Justice of Appeal Webster, having considered Salford, point 1, and therefore the English Court of Appeal's view as to what policy it was appropriate to adopt in England, because that's what Salford says, expressly declined to follow. Could I show you very briefly, just so you have it, I'm sure you've seen it, 1833, please.
Sorry, page
1833.
33. Thank you.
So it's 47, and this is in Jinpeng. Position, no, the Chancellor is obviously Chancellor Etherton in Salford. Position outlined by the Chancellor in these passages comes close to the automatic stay provision. I echo respectfully that submission, which is now firmly part of the learning in connection with Section 18 of the Arbitration Act. That's the mandatory stay. He's saying in very clear terms that a winding up application based on a debt that's covered by an arbitration agreement will be stayed unless there are exceptional circumstances. And then here's the ratio. However, I do not think that a creditor should have to prove exceptional circumstances. So first of all, there's a threshold, and secondly, there is the onus. Creditor should have to prove. This court's judgment in Sea Mobile sets out and distinguishes the BVI statutory jurisdiction to wind up based on and so forth, unless the debt is disputed on genuine and substantial grounds. Then he says, this principle is too firmly a part of BVI law now. Can I just stop there? Learned friend addressed that point as though the only parts of BVI law where one could establish a principle are in the Court of Appeal. But these principles are applied week in, week out in the insolvency courts, and Jinpeng is followed regularly. Too firmly a part of BVI law to require a creditor exercising the statutory right belonging to all creditors of the company to apply to wind up the company to prove exceptional circumstances to establish his status to apply. Statutory jurisdiction is satisfied once the creditor is applying on the basis of a debt that is not disputed on genuine and substantial grounds. So that's my eyes wide open point. The test is applied and repeated at paragraph 51, just as your lordships have it, 1834 to 1835, nothing added. I've made the two firmly part of the BVI law tie-in to UREN, that submission. The third reason for respecting the local jurisdiction is that the stay discretion is not an issue where reasoning can lead to only one conclusion. It just can't. It's a discretion, and it's clear, well, I needn't develop that any further. Next, the consequences of imposing Salford in the BVI are important. Some of these matters I've already referred to, so I'll deal with them quickly. Firstly, the rule in Salford would, in practice, lead to the dismissal, as opposed to the stay, of BVI petitions in almost every case because of the operation of Section 168. That's an important statutory difference between the BVI and England. We deal with it in our written case at paragraph 93. I won't develop it other than to say that Eastern Caribbean Court of Appeal Authority referred to in my written case, but it's at pages 1878 to 1898, a case called Catherine with a Y, Ma, Wei, Fong. That case held that Section 168 reflects a BVI legislative policy that applications to appoint liquidators should be dealt with expeditiously. As I say, there's no equivalent of Section 168 in the English Insolvency Act. I've made the vulnerability point, period point. Don't want to develop that any further. Can I come to learned friends' points about consistency or inconsistency with other jurisdictions? We say there's very little to be gained from the, as it were, the survey, comparative law survey that both sides have gone into. It's plain that the state of the law is very unsettled. We give some discussion about that. The role of foreign precedent, of course, with all due respect to the learned author, is dealt with in the learned article by Lord Reid, which we refer to. The fact that a foreign tribunal follows an English court decision is neither here nor there. The only additional learning that this board will gain is if some additional reason or principle is given for or for not following the point. And we've explained that there are few, if any, persuasive reasons in any of the cases, least of all in my learned friend's favourite case, Annan, which was plainly wrong, because Annan treated a petition as a claim. It sets off on the wrong basis and gets, therefore, the wrong conclusion. At their very highest, the foreign authorities in our submission repeat the reasoning in Salford, other than perhaps the consideration of the law by Mr. Wong, Senior Counsel, in his case. We've grouped those authorities at paragraph 65 of our written case into 4 categories. Again, that can be read if any illumination is required. A word or two about each jurisdiction. Singapore, but really a word or two. The Annan case in Singapore goes wrong because it treats, it locks onto and it treats the, as I say, the petition as being a claim. Now, it's common ground that a petition isn't a claim for the 5 reasons given by the Chancellor. The second reason that Annan is of no persuasive assistance. It doesn't have to be wrong, it's just of no persuasive assistance. There's my paragraph 70, is that it said that it would encourage the abuse of the winding up jurisdiction of the court. But that, with respect, only expressly repeats and thus adds nothing to the Chancellor's concern at paragraph 40, and is misplaced respectfully for the same reason that we give and I will come to. The third reason why Annan is of no persuasive assistance is it takes the point at paragraph 65, bundle 1022, that a mandatory stay of an arbitral claim would be refused only where the arbitration agreement was null and void, inoperative, or incapable of being performed. But with respect, that misses the fundamental point that a winding up petition isn't an arbitral claim, so there is no mandatory stay. And then my learned friend talks of party autonomy. And this point is also used by my learned friend not only to support Annan, but to support one of the justifications he puts forward for Salford. What he says is an arbitration agreement must be given its due weight. But we say, yes, of course, but only when it's relevant. And it's not relevant for all the reasons I've already set out. And the key reason is that a petition does not resolve the underlying dispute. Therefore, party autonomy is irrelevant to the collective remedy of winding up.
I see that in Jianping, the parties actually were in an arbitration, which makes it a very strong authority. As notwithstanding there is an arbitration ongoing, the court is prepared to say that there is no genuine and substantial dispute.
Yes.
And therefore the arbitration doesn't matter.
Yes.
Now, I suppose that's something we have to contemplate if we were to be critical of Salford, that equally here people would be able to seek winding up on the basis that there's no genuine substantial dispute, notwithstanding that arbitration proceedings may be underway. Yeah.
Mr. Willens, who is my BVI expert, reminds me that the arbitration in Jianping was commenced only after the first instance judge had struck out the winding up petition. So it came afterwards.
Right.
So I had missed that point, but Mr. Willens is here for good reason. That's my apology. Now,
yes, although I'm not sure he bases his reasoning simply on that. Well, we're looking at paragraph 51, which is on page 1634.
yes.
He says, in the circumstances where I found the dispute between the parties is not on genuine substantial grounds, and the respondent can't account for treasury bonds that have gone missing, it's incumbent on this court to make an order for independent persons to be responsible for what has happened. This is so even though the parties are now arbitrating the dispute.
Yes. That was at the stage of the Court of Appeal, I think.
Yeah. Okay.
It was 1834, just for your lordship's note.
But I suppose, I mean, even if on the facts, the arbitration had been commenced after the winding up petition was presented, in principle, would that matter? Would it not be? I mean, if your approach is right, would it not be possible for the creditor who is party to the arbitration proceedings, nevertheless to seek a winding up on the basis that there is no genuine and substantial dispute.
Yes,
Yeah, I think that's a logical implication.
it must be. Yes. Because it's not a requirement to start arbitration, nor can it be a complete answer that I have started arbitration. Otherwise, that would just be the abuse.
Yeah.
Of course, I'm very conscious in answering the question that way, not to trample on that which Lord Hamlin described earlier as trampling on the arbitrator's feet, because the court would have to go gently, but it would have to apply the test that it's mandated to apply on the winding up petition, which is a threshold test. It's not a resolution.
Just before we leave, I don't know whether you're coming to the end of the section of looking to other jurisdictions. Your argument is it's inconclusive. It might be said against you that all these other jurisdictions have followed Salford Estates, unless it's the case that, well, including potentially Hong Kong. As I say, I was left unclear what your final position was on Hong Kong. Clearly, that first instance judge is very much in your favour.
I'm coming to Hong Kong now, so if I may... Then
okay, certainly, sorry.
I didn't do it elegantly earlier, and therefore your Lordship is right to ask me. So if I can just... I was dealing with party autonomy. I think I was going to be coming to... Yes, I am. On party autonomy, we say also that Sian's argument on party autonomy goes too far, because even in the analogous field, and it's not only analogous of the choice of forum clauses, party autonomy is not a trump card. The courts have a discretion and no more whether to stay, and then only if there are strong reasons. See Donohoe and Armco at 1357 Lord Bingham, and that's been applied in the BVI in Garkusha, Garkusha, at authorities 1560, but that's just citing and applying Donohoe. 1540, I'm sorry, learned friend says. Now, the English approach to winding up petitions, relying on debt subject to arbitration clauses and exclusive jurisdiction clauses, is inconsistent. See our written submissions at 101. And if the underlying justification were party autonomy, then one would expect there to be uniformity of approach in an ideal world. We make other points about An, that's where I was, and dealing with the reasons that learned friends seek to support their best case. And I'll move to Malaysia, and the key point here is that in the V Medical Services and Swiss Re case at 2392, there are no reasons over and above Salford that are given. See our written case at 75 to 76, and also in our respect for submission errors, such as treating the winding up petition as a claim. See paragraph 28. Now we move to Hong Kong. Now we started with Lasmos, and that is the case where the court required the debtor company to take the steps required under the arbitration clause before staying. Prior to Lasmos, the only question under Hong Kong law was whether the debt was bona fide disputed. So Lasmos added the layer, Lasmos in 2018, of requiring the court to take that step. That has been doubted, that decision, by the Court of Appeal in Hong Kong in a case called Butt, B-U-T, K-A, Chon, 2019 in Authorities Bundle Tab 20.
Page?
I'm sorry, I'll give it to you now. It's 1178. Then we come to the Diang case that I've mentioned several times, where Mr. Wong, senior counsel, went further and he said what he did about Salford, the conceptually muddled and antithetical to the nature of discretion. If I can recommend an excellent and very succinct analysis of the state of the law, the head note, for your Lordship's note, in that decision, which you'll find starting at 1274, makes for good reading, particularly paragraph 12 of the head note 1278. It's all obiter, but he says what the present state of the law is and what it should be. What he says at 1278 is the present state of the law could and should be stated as follows. One, where a debtor company intended to dispute the existence of a debt, it must show that there was a bona fide dispute on substantial grounds. It could not merely deny the debt. This test applied whether or not the debt had arisen from a contract incorporating an arbitration clause. The existence of an arbitration agreement was irrelevant to the exercise of the discretion, and the fact that arbitration agreement proceedings had or would be commenced may be relevant evidence of a bona fide dispute, but this alone was not sufficient to prove such dispute.
Do you rely on point D as a possible answer to the Chancellor's concern about the abuse of the winding up process, where there is, in fact, a bona fide dispute as to the debt? That your risk of
yes, well,
paid.
that is the classic result,
Yes.
which is if one brings a petition and there is a bona fide dispute and you know it, then you risk paying the debtor's costs on an indemnity basis, and that's the in re company decision of Mr. Justice Hoffman, as he then was, back in the 1980s, I think 83 or 86, which is applied to this day, I believe, in the Companies Court. The one point that didn't fall for consideration on the facts in that case, because it didn't arise, but we have over and above these points, is that of the circumstances where litigation had been started as opposed to arbitration. So that is, as it were, open territory, because in that case, and in all the other cases, the issues were whether arbitration had been started, locking into C, whether arbitration had or hadn't been started. But we say that where litigation has been started, that certainly goes to the discretion, if not it being conclusive.
Sorry, I didn't catch that.
It certainly goes to the discretion, and it may be thought to be an overwhelming discretionary point if litigation has been started whilst complaining to the court that there should be a stay for arbitration. It doesn't matter in our submission whether that's in the context of an allocation of jurisdiction clause or an arbitration clause. You act contrary to them. In Guy Lam, the next case, the dispute resolution clause on a petition was again an exclusive jurisdiction clause, and I've mentioned that case. The Hong Kong Court of Appeal held that the correct test was strong reasons, page 133. This ruling was upheld by the final Court of Appeal at 104.
104.
104.
Of which bundle?
Of the first bundle. It's paragraph 104, page 1679.
Thank you.
So in sum, the first instance decision, and then the first instance decision in Hong Kong following on, are inconsistent on whether the rule in Salford Estates, as applied in Guy Lamb, also applies to arbitration agreements as opposed to just for exclusive jurisdiction agreements. And learned friend mentioned re-simplicity, where it was said that the rule only applies in exclusive jurisdiction agreement. I think we put a footnote that simplicity was scheduled to be argued on appeal just recently, but we haven't yet found a judgment. So if it comes, then we'll let you have it, of course. Now, New Zealand we mentioned briefly, but it doesn't really advance the case at all. English law we submit is inconsistent in its approach to different dispute resolution clauses. So in the case that learned friend referred to earlier and tried to read down because he said it hadn't been properly argued and so forth, Lord Justice Jonathan Parker's decision in BST Properties, that's at 31 to 32, 1177, was held that an exclusive jurisdiction clause, importantly not an arbitration clause, exclusive jurisdiction clause in favour of a court in Hungary did not, and now I'm quoting, did not affect the question which was facing the company's court, namely whether the petition debt is bona fide disputed on substantial grounds. So the court could go on regardless of the exclusive jurisdiction clause, 1177. So the ratio of that decision is that the court will not stay a petition because of the presence of an exclusive jurisdiction clause.
Is there a case, English case, which considers the exclusive jurisdiction clause position as a matter of principle?
In the context of
winding up?
Well, no, apart from there's a bit of skirmishing going on at first instance, I'm afraid.
That seems to be choosing between authorities to follow.
Yes.
But there's no analysis.
No, not that I know of. No. I'm afraid there isn't, which is part of...
Well, in your case, is there a reason for there to be a difference? No.
No, these are allocation of jurisdiction clauses. It doesn't matter if it's an exclusive jurisdiction clause to another forum or to an arbitration or to an arbitral tribunal. For these purposes, I can see differences in other regards, but for these purposes, there shouldn't be any distinction. And if this court was looking to align the approach, I offered Donohoe as the starting point earlier. The last topic that I'd like to discuss, if I may, is Salford is wrong. So if I'm wrong about the BBI being take a different approach, and there needs to be one approach, then the wrong approach is Salford. The starting point on Salford is that much of it is correct. It just took a wrong turn at the end. Your Lordships have had from Mr. Morgan the facts to some extent, and I won't repeat them, but you'd find them in our written case at 24. The correct approach of the court, in my respectful submission, is encapsulated in the submissions of counsel in that case, which the court accepted to a certain point and then departed from. May I show you those submissions very briefly, which are then picked up in the judgment? 2278, please. Not one of those circumstances where it runs over many pages. It's very succinct. And in that case, Learned Counsel, Miss Anderson, then Queen's Counsel, submitted that the court should only stay or dismiss. Well, I won't read it out, but we agree until we agree all the way through. When the court has seen that, that is picked up and recited in shorter form, just for your notes, at paragraph 25, 2283 to 4. Just show you that. It's only about 4 lines.
Paragraph.
It's paragraph 25.
Thank you.
2283 to 4 at the bottom of 2283 over. That's picked up. Reference to established jurisprudence. Now, as we say, we would invite this court to accept that reasoning and to reject the wrong turn that happened at paragraphs 39 to 41 of Salford. The reasons we give for that submission are as follows. 1, as I submitted in my opening, propositions and is common ground, and I hardly dare say again, a petition is not a claim. That's the starting point. It falls outside the statutory framework. The reasons it's not a claim are the 5 reasons given in Salford at paragraphs 31 to 35. 31 starts at the bottom of the very page that may still be on the screens, 2284, and each paragraph, 31 and so forth, contains one of the 5 reasons why it is not a claim. So it's the jurisprudential basis for the difference. And there's no difference between us on that. Senior Learned Friend's written case, it's 17 and 28. I won't read those out. But you see it in the last, which is at 35, that the court found it highly improbable that Parliament, without any express provision to that effect, intended Section 9 to confer on a debtor the right to a non-discretionary, i.e. mandatory order, striking it at the heart of the jurisdiction, and discretionary powers of the court to wind up companies in the public interest where companies are not able to pay their debts. So we're into the language of the intention of Parliament, which is policy. Now to the core issue, which is in our submission where Salford went wrong. The parties disagree about whether the Chancellor was right at 39, so if you could very kindly turn down 2 pages, please. Have that on your screen, so it's at page 2287 for your note, paragraph 39. We disagree about whether the Chancellor was correct at 39 to uphold Mr. Justice Warren's so-called alternative analysis in the earlier case of Rossant, which you'll have seen referred to in the submissions of counsel, where Miss Anderson had submitted that Rossant was incorrectly decided if the court needed to go there. The first key element in our submission of paragraph 39 is that it refers to the winding up merits discretion in section 122(1) of the Insolvency Act. Again, part of my opening propositions. Secondly, it sets what effectively has become a precedent, although it has been described elsewhere as a fetter on discretion, where in the passage which starts, it is entirely appropriate. It's entirely appropriate that the court should, save in wholly exceptional circumstances, which I presently find difficult to envisage, exercise its discretion consistently with the legislative policy embodied in the 1996 Act. So what is being decided? This is what's being decided, then I'll go on to explain why we say it's wrong. One, that there's a fetter on the exercise of the merits discretion. And two, the fetter is so comprehensive as to effectively remove the discretion altogether. And the board will remember what the Hong Kong authority said about that. Then
So what is the legislative policy embodied in the 96 Act that's being referred to?
Yeah, well, it's difficult to tell because it doesn't explain it other than that there should be stays for arbitration.
Do we have to look at paragraph 19 of Mr. Justice Warren's judgment in Roussant?
Yes, we
in the bundle.
We do in a moment. If I may just finish this, and then we'll go back to Roussant and deal with that. So the next point that I want to take here is that Lord Justices Henry and Swinton Thomas had considered in Hulkey that the intention of the legislature in enacting the 1996 Act, so this is where we get the best description of that, I'm sorry, I misspoke just now, was to exclude the court's jurisdiction to give summary judgment, which had not previously been excluded under the Arbitration Act 1975, so that was a big change. It would be anomalous in the circumstances for the Companies Court to conduct a summary judgment type analysis. The board had this debate with my learned friend this morning. It's a summary judgment type analysis because in looking at whether or not there's a bona fide dispute, there needs to be a merits threshold which has been equated to the summary judgment test. It would be anomalous in the circumstances for the Companies Court to conduct a summary judgment type analysis of liability for an unadmitted debt. Now, if we could just stop there. This was a case about an unadmitted debt. And it could be argued that, and I hate to shoot another fox, that Salford has absolutely no application to this case in any event. Because Salford was a case about an unadmitted debt. And in this case, the debt is admitted. On which a winding up petition is grounded, when the creditors agree to refer the dispute to arbitration. Exercise of the discretion otherwise than consistently with the policy underlying the 1996 Act, when it inevitably encouraged parties to an arbitration agreement as a standard tactic to bypass the arbitration agreement in the 96 Act by presenting a policy. Then there's the applying pressure point. And then that would be entirely contrary to the parties' agreement as to the proper forum for the resolution of such an issue and to the legislative policy of the 1996 Act. Now, just one or 2 points on that. You'll have noticed that although this was a winding up case, learned judge didn't discuss the policy underlying the insolvency legislation. And having taken the view that correctly, that the arbitration acts are not applicable, he then applied the policy of the non-applicable acts. In a case about winding up, where he didn't apply the policy of the insolvency legislation. And if this board needs any reason to interfere with that, then there's a good reason. Now, Salford takes a wrong turn. Paragraph 19 of Roussant, Lord Briggs asked for, and quite rightly so, just may I show it, is at 2271, paragraph 19.
2271.
1. Ruscent. Yes. So,
But the Companies Court doesn't decide summary judgment claims.
no, it doesn't. It's just not right. In our we do give a commentary on Ruscent in our yes. So there was a disagreement. The Chancellor had disagreed at 38 with a view expressed by, this is from 26 of our written case, with a view expressed by Ms. Justice Warren and Ruscent. That's an issue on a winding up petition, which is essential to the foundation of the petition, becomes a claim and falls within section 9. So Ruscent was wrong on almost every ground, but then the in our written case at paragraph 21, to answer the question, we dealt with the development of this line of authorities. Statutory demand to 21, so after the Halkian, Ruscent and Traxxas, creditor, statutory demand, immediate repayment of principal and interest, the loan agreement. Debtor argued that reliance on statutory demand is precluded by the arbitration provisions. Ms. Justice Warren accepted that submission. Did you see what he said there? And we give our, we give the reasoning set out. In the light of that, whatever the judge made of it, the court then went on in Salford the court then went on in Salford to purport to apply Ruscent in coming to its decision in the application of what it called the policy of the Acts. And we say for that reason that Salford is plainly a policy-driven decision. That's wrong. Firstly, as I've said already, the policy of arbitration law applies only to arbitral claims, and these proceedings, winding up proceedings, are not. Secondly, if there is a policy to be weighed, we say that insolvency policy must outweigh arbitration policy, because notwithstanding party autonomy, the protection of creditors, because one needs to set rules for the whole of the jurisdiction, not just for the individual case. Protection of the public from the trading of insolvent companies must trump, if there has to be a trumping, insolvency policy. And as to the three concerns, which I've shown the court at paragraph 40 of the Chancellor, we deal with these at paragraphs 34, 35 and so forth in our written case. There were three concerns given by Ms. Justice, by the Chancellor. The first was that there would be some usurping, I think, of the Chancellor said that it would be anomalous for the Companies Court to conduct a summary judgment type analysis of liability for an unadmitted debt in which a winding up policy was grounded. And we say that that proceeds on the wrong premise, because there will not be the need to resolve anything finally on the petition. And I did notice that Learned Friend started to develop an ever more elaborate argument about referring the insolvency question to the arbitrators as the only logical answer to that question. Family Mart. The Chancellor held in that case, in this case, in the Salford case, and it's also been held in the Privy Council, I think in Family Mart, although I may be wrong, that the allocation of insolvency is only to the courts, whereas debts can be resolved both in arbitration and at court. And there is a good reason for that. And that's the public policy argument. If you were going to let arbitrators decide whether to wind up insolvent companies or not, then that would be evidence of a different policy. But the fact that that's kept away from them must be an important reason. Lastly, pressure, that is not confined to arbitration cases. Now, as to dealing with the so-called tension between the two policies, the fundamental point is that there is no tension, there is no policy, because there is no application of the statute. But if there is a tension, and I'm sorry because I must leave my learned junior a moment or two, then may I ask the tribunal to consider our submissions at paragraphs 44 and thereafter, which try to resolve that question. But on any view, if there is any conflict between the policies, such as they are, whether they be of the court or anybody else, in favour of a trump, then that must fall on the side of insolvency because of its wider public protection, not the narrow interests of parties who wish to litigate disputes. Lords, I think I've just about come in on time. Have you any questions for me at this stage, given that?
There is just one overlying question that is just bothering me, and that is, your argument is that Salford Estates is wrongly decided. What are you actually asking us to do if we reach that point?
What I'm asking you to do...
I mean, can we overrule an English decision?
No.
I mean...
No. What we say is that we have put before the tribunal several reasons for deciding this case in our favour. My intermediate one was Jin Peng is right. If Jin Peng is wrong, then I've given reasons for why Salford should not be applied in the BVI, and I've suggested alternatives. That's the logical framework into which. So
you're not taking us to Willers and Joyce or any of that in terms of what the Privy Council's powers might be?
Not at this stage. It's not necessary for what I need to do.
Thank you.
Yes, Section 168, I couldn't remove the adjective. It's special circumstances. Thank you to Mr.
Yes, thank you very much, Mr. Lowenstein.
Mr. Hamilton will take the jurisdictional threshold
I'm
point.
afraid you'll have to take it very briefly. Mr. Hamilton.
Yes, I will. I appreciate that. I will seek to do so. My Lord, the question is whether the appeal involves directly or indirectly a right which is valued free of counsel. The respondent says the test is not satisfied with two principal reasons. The first is that which emerges from Jackpot, which is the leading authority board on that issue. The point in that case, and we say the reason applies here as well, is that was an appeal from a decision by the gambling authority to revoke the licence. That was a decision which matter of discretion. In circumstances where it was an appeal from a decision on discretion, the appellant Jackpot didn't have any right to a gambling licence. All it had was a right to a fair hearing, and that was not a right of financial value. We say that that reason applies here. The court has a discretion to make a winding up order in the same way that the right that the respondent in this case had was simply to a fair hearing of its application. As far as my learned friend sought to suggest that Jackpot can be distinguished on the basis that it is a judicial review case, I won't take your lordships to it, but paragraph 16 of the judgment in that case, which is at page 1806 of the bundle, their lordships highlight my submission there that there's no special treatment that applies to judicial review cases. My submission that is a non-point. In relation to the question of whether Mr. Justice Warbank, stepping back, the most relevant case that applies or that addresses the reasoning as to whether there should be an automatic right of appeal against a winding up order is the case of Virginia Solution, which is a very recent decision by the Cayman Court of Appeal. Again, I don't propose to take your lordships to it in my time, but it starts at page 2419 of the bundle. It's a very strong panel. Sir John Goldring, Sir Alan Moses, and John Martin Casey, and they essentially follow the reasoning Jackpot in concluding that as I've submitted an appeal against a winding up order, in that case winding up on just inequitable grounds, is not the right to a fair hearing or the valuable right. That case also involved the question of what it means to say that an appeal involves a particular right, whether indirectly or directly. The reasoning is set out paragraph 9 of their judgment. That's page 2424 of the bundle, and that reasoning is applied to paragraph 10. In short, the Court of Appeal found that the right that was relied on in that case, which was the shareholder's right to share in the assets of the company, was not involved in the appeal. And that was because whichever way the appeal was decided, the shareholder would still have that right. And we say that's precisely analogous with this case. Your lordships have the point that the winding up petition does not alter the debt between parties. The debt remains outstanding. If the proof of debt is not accepted by the liquidators, it may well end up going to arbitration. My learned friend's contention that the status of Halimeda's alleged claim was an issue which Mr. Justice Warbank considered at first instance. Again, we say that doesn't accurately reflect the position. The debt was not the subject of any determination. Mr. Justice Warbank relied on the debt and in winding up petitions on the basis of an unpaid debt. The debt is evidence of insolvency. It is not itself an issue. It wasn't an issue in this case. And in our case, an additional reason applies, which is, of course, that there is no longer any dispute that the debt is not disputed on genuine and substantial grounds. So in any event, my friend fails in fact at that point. In relation to the cases relied upon by my learned friends in their written submissions, we weren't addressed on those. There are 4 cases. We say that none of them exist. None of them is comparable to this case. None of them involve winding up. And in every one of them, it's readily identifiable how the outcome of the appeal had an impact on the parties, which either had a straight financial impact on them or could obviously be linked to a valuable property right. That's all I wish to say, my lords.
Thank you very much, Mr. Hamilton. It's commendably brief. Mr. Morgan.
My Lords, I think I had 20 minutes. I lost 5 minutes this morning, so I think I have about 15 minutes.
Well, we'll give you 15 minutes then.
Oh, my Lord, I will do my best to get through these points. I'm going to deal with them in response in the same order as the points my learned friend made, which I hope that is at least reasonably helpful from a note-taking point of view. Well, the first point I wanted to make is that this is not an undisputed debt within the meaning of the test in the Halki and Salford. There is an issue between us as to whether we should be in that territory, but if we are, this is not an undisputed debt, and it's wrong for my learned friend to characterise it in that way. We do not accept that we are liable for the debt by reason of the set-off arising from the cross-claim. There has been a judicial determination that's not a genuine and substantial dispute, which we are stuck with, but that is not the same thing. My Lords, my learned friends talked about the sequence of proceedings as a bit of colour or, no doubt, prejudice. My Lords, we say this is entirely chicken and egg. What we say that should have happened is that Halimeda should have commenced an arbitration against us, which would have been met by reliance on the set-off in the form of the unlawful means conspiracy, as exactly as happened in the mirror situation with Maple Ridge, which is the subject of arbitration proceedings by Halimeda in respect of unpaid debt, where the defence is this same conspiracy claim. And as my learned friend rightly said, it has been held as a matter of principle that the unlawful means conspiracy can, subject to the facts, give rise to an equitable set-off against the debt and therefore a defence. Lord, it's emphatically not the case that we have abandoned the unlawful means conspiracy, whether as a set-off to the debt or at all. In the English proceedings, Halimeda has been included, and its allegations are made against it as a conspirator, but there is no claim for damages against it. That was explained in evidence which has been filed, and the explanation is to avoid potential arguments as to arbitration and whether or not we waive the right to arbitration. There is no abandonment of this point as a freestanding claim or as a defence to the debt claim. And there's no inconsistency in that, my lords. Turning to case management, briefly, our submission is that the court has to focus on the first instance decision and that the Court of Appeal decision is of little or no assistance. We referred in our written case to a case of SB in Sri Lanka, which is at 2289 in the bundle, which makes exactly that point. And the rationale is that if the first decision was wrong, it isn't improved by the second decision. It should have been, the court should conclude it should be set aside. And the Court of Appeal in England just discussed that issue. And there's a particular reason for that, my lord, in this case, in that, of course, below, we couldn't argue that Jim Peng was wrong. The Court of Appeal was bound by its own decision, and therefore the arguments were necessarily constricted and restricted in a way that is not the case in this court. And so if the discretion was being re-exercised now on the basis that Jim Peng was wrong, it would look very different. My lord, my learned friend referred in his written argument to paragraph 124 onwards on case management. Just to be clear, my lords, that is based on the assumption that lateness was a standalone point, which I've already addressed you on, as the illogical argument underpinning that and our rejection of it. And then moving on to more next point which he made, which is that they meet any test. I think the focus was put on the raising of the claim in the BVI. We would respectfully agree with Lord Hamblin, and that if you're going to get into matters with that, or the suggestion from Lord Hamblin, that really has to be remitted. It is, in our submission, strongly arguable that the unlawful means conspiracy, as a freestanding claim, was not caught by the arbitration clause. In those circumstances, commencing that claim was not a breach of the arbitration agreement, let alone any form of repudiation of it. So the court is clear, the debt claim was not put in issue in the BVI proceedings by either party. So, my lord, there is no necessary inconsistency between the commencement of those proceedings and the retention of arbitration as an argument in relation to the debt at all. And my learned friends, although they seek to step back from it, are really asking the court to say there's a repudiation without actually asking the court to do so. I think my learned friend described it as a probable repudiation, which is an interesting concept when you're not resolving it. So we reject that argument and the others as to meeting any test. My Lord, then just considering BVI as a potentially different jurisdiction and an approach. My learned friend made a number of points of factors as to why BVI should be different. We make the observation that none of those were referred to in either C-Mobile or Jim Peng as the reasons for the judges arriving at those conclusions. To a certain extent, my learned friend's submissions were entirely speculative. In terms of Jim Peng itself, my lord, I'm sure the court has the point that it doesn't follow from Jim Peng that just because there isn't a genuine and substantial dispute, the court doesn't have a discretion not to make a winding up order. That's clear from C-Mobile and Jim Peng itself. I'd made the point, I think, earlier, that in Jim Peng the court had found that there would have been exceptional circumstances in any event. There are not a series of cases which clearly show how the court will exercise that discretion where there is not a genuine and substantial dispute. In other words, I think it remains open to debate how much of a gap there is between the Jim Peng approach and the Salford Estates approach on the facts of any particular case. Particularly in circumstances, and I'll come back to this in a moment, where one of the big and important exceptions in Salford Estates, or we would say should be recognised, is the protection of creditors. My lords, my learned friend referred to the single creditor point, which we had made in our written case, and Lord Burrows picked up on. We would note that in Ann that was identified as a particular factor. That's paragraph 71, page 1025. And we would say, my lord, that this is an important, if there is a single creditor case, it is important because there are no wider interests to be protected. Of course, in England, there are often other creditors to be protected, but that hasn't stopped the development of the approach in Salford. And that where one has a single creditor who, for these purposes, let us assume, cannot show any risk to assets requiring a provisional liquidator to be appointed or for avoidance transactions to be preserved, the difference between ordinary court proceedings and winding up proceedings, we would submit is not significant. We would just add, and I insisted by Mr. Kite from Harney's, who's my BVI expert, there are, of course, local creditors. There are local companies in the BVI, such as hotels and restaurants, who might be expected to have creditors. So we're not sure where that goes. My lord, in going back to Jim Peng and the ratio, if we could, perhaps I could take you back to what my learned friend said was the ratio, and that's Jim Peng starts at 1809, and your lordships will find paragraph 47. Which is at 1833. He concluded by saying the statutory jurisdiction under section 1621B is satisfied once the creditor is applying on the basis of a debt that is not disputed on genuine substantial grounds. Your lordships have section 162 in the bundle. If I could take you to that. That's at page 899. And your lordships will hopefully see 1621B is in fact the just and equitable winding up provision. The important point is the discretion which comes in that the court may, in 1621, is the vehicle by which we say the court exercises its discretion as to how far to consider a debt in any particular case. And an arbitration argument can be, as can be seen from the sort of failed facts of C-Mobile, an alternative to the genuine and substantial test. So you could say, we say there's a genuine substantial test, but if there's not, in any event, you should stay as a result of arbitration. They are, in our submission, alternatives. And that was not something that was grappled with by the court in Jim Peng in any proper way. Well, while we're on the international angle, on Annan, which we have relied on, we don't read that case as having treated the petition as a claim. There is a reference in the Malaysian case, Awasanga, to the statutory demand being treated as a claim, but we haven't seen that in Annan, and no doubt your lordships will look at that when reviewing that decision. In terms of my learned friend's reliance on Dayang in Hong Kong, my lord, in terms of the chronology, that came before Annan in Singapore, and it didn't follow that approach. And it was then followed by Gai Lam. I wonder if we might, if the time permits, just briefly go to Gai Lam in the final Court of Appeal, because this is we say, at least at the moment, the most authoritative consideration of these issues in Hong Kong. If your lordships, could I trouble you to go to 1672. Your lordships will hopefully find there, at paragraph 60, one scrolls through to 70, the appellant's arguments. And your lordships, when skimming them now, and no doubt in more detail later, will see the familiarity with those arguments between those that have been adopted by my learned friend in this case. And those arguments were essentially rejected for the reasons which Mr. Justice French gave. In particular, one can probably start at 96, paragraph 96, 1679, through to 102. And I don't have time to unpack those for your lordships, but those essentially are the key points rejecting the appellant's arguments and identifying in the context of exclusive jurisdiction clauses why there was a policy engaged and why it wasn't trumped by insolvency policy, or in other words, how they could work together. And we say there's no reason to take weaker protection. There's no reason to adopt a weaker protection for arbitration than for an exclusive jurisdiction clause. And that reasoning there is, with all due respect to the English court in BST, well, it is actually reasoning, and our submission is sound reasoning. My Lords, I think, finally, as Lord Hamblin asked, well, what is the policy behind the Arbitration Act? I think the Arbitration Acts, the best that we can do at this stage is to show you Section 3 of the BVI Arbitration Act, which is in similar terms to the Section 1 of the English Arbitration Act. And your Lordships have that at 889, which in turn derive from UNCITRAL. And if your Lordships have that, the Act is founded on the following principles, which include that B, the court shall not interfere in the arbitration of a dispute. And it may be said, we may say, well, it's only in relation to claims caught by Section 9 why there might otherwise be interference. We say that's too narrow an approach to it, unless the Arbitration Act is a complete code, which for the reasons I gave earlier to my Lord Hamblin in relation to the operation of Section 37 is not the case. And we say that this case illustrates the problem. What should have happened is there should have been an arbitration with the set-off. If that had been resolved in our favour, there would have been no liquidation at all. That would have avoided enormous costs, conflict liquidators, and loss of value in the company. On the other hand, if the arbitration had resolved the matters against us, this would have been a simple liquidation with no need to bring unlawful means conspiracy claims, because there would be an issue of estoppel in relation to that issue. And where one has an incoming claim, such as in the present, no liquidator is going to refer that question to arbitration, even if he could do so. So one has a situation where the decision has been made at the wrong point by the wrong tribunal, rather than by the correct tribunal. And that has had dramatic effects, we say, for both creditors and shareholders in relation to the company. And my Lords, one of the final points I want to make is this.
Well, one of the final points, and you're out of time, Mr. Morgan.
That's all right, this final point, which is this, my Lord. If the Insolvency Court is concerned with protecting creditors, and one of the exceptional circumstances is to allow for the protection of creditors, that is an important and significant difference with ordinary court proceedings, and shows that the discretionary stay is not a mandatory stay by the back door, because the same considerations would not apply in an ordinary court proceedings. My Lords, I will stop there.
Thank you. Well, we're grateful to all counsel and those behind who have no doubt assisted. We'll consider the submissions and consider the advice that we will humbly tender to His Majesty. We'll adjourn.